Hi, I'm Erin Nobles, and I'm an estate planning attorney licensed to practice in Massachusetts and Florida. Sometimes clients come to me and they tell me that they're planning on relocating from Massachusetts to Florida, and they want to know what this means for their estate plan. As a threshold issue, because of the full faith and credit of the U.S. Constitution, your duly executed estate plan from the Commonwealth of Massachusetts is going to be valid no matter where you move within the United States. However, there are significant differences between the law in Massachusetts and the law in Florida that you want to be aware of and that might necessitate some changes being made to your estate plan. One very significant difference might be that once you've actually moved from Massachusetts to Florida, established residency there, and liquidated any real property that you may own in Massachusetts, your estate will no longer be subject to the Massachusetts estate tax, which, as you may know, is the lowest threshold in the country for applying that tax. That sounds like great news, and it is. However, this may mean that an estate plan created in Massachusetts that contemplated those taxes applying is now too complicated and might be overly burdensome for your Florida-based personal representative to administer. You may want to speak to an attorney who's licensed in both jurisdictions about making changes to your will or to your living trust due to tax clauses that may not apply anymore. The second significant difference has to do with your advance directive for medical care, because the law on this issue is very different in Massachusetts than it is in Florida. In Massachusetts and in Florida, you can nominate a proxy, and a proxy will make medical decisions for you if you become incapacitated or unable to convey to your doctor what kind of care and treatment you would want. However, Massachusetts law does not recognize the living will, and the living will is a document where you would specify the types of interventions that you would and would not want under specific circumstances. Florida does recognize this document and allows you to get pretty granular about what you would want done and what you wouldn't want done. So, if you have a Massachusetts advance directive, the attorney who prepared it for you most likely didn't include a living will because it wouldn't be enforced in Massachusetts. So, speaking to an attorney licensed in both jurisdictions can help you get a complete advance directive for medical care. So again, if you're contemplating a relocation from Massachusetts to Florida, there are many reasons why you might want to speak to an attorney. Other reasons might include other tax differences and the difference between the Massachusetts and Florida homestead law, which is significant. If you have questions about any of these issues, you can reach out to us at info@nobleslaw.org.